But it's not just college. It's really anybody that is turning 18. There are certain things that you might have been able to do for your child as a parent when they were a minor, but then as they become an adult, you're not able to do anymore. And that's just the way the law works with information privacy purposes, things like that. So welcome everybody. As I mentioned a second ago, I'm attorney Justin Randall here with Hooper Law Office. Our topic today is on the different documents that your college age child or new adult child should have in order for them to have you still step in for them if there's ever a health concern for them, like an incapacity, or if there's any reason that they just need your assistance still with anything. And I mean, just because someone's 18, you're legally an adult, but if I'm speaking from experience here, just as I'm sure all of you have dealt with this yourselves, right? Just because you're 18 and an adult doesn't mean you always feel like it or are fully able to handle everything right away. There's certain things that you might still rely on your parents for in terms of advice or having them help you out with filing taxes for your first time. I mean, there can be a lot of different things. And for the longest time too, I was not aware that there were certain things that I needed to have for myself so that my parents could have health information even as a new adult, because it was just something that as a child, you're used to being, accessible to them. So this is really all about the different documents that anybody should have once they turn 18. But in particular, if you as a parent are concerned about your child not having these, it's a good conversation to have with them. So just a couple of things before I go too in depth on anything, as is always the case with these, if you have any questions or concerns that you would like to shoot over to me, there is, if you're on Zoom, there's a chat function or a Q&A function that you'll see. I see those questions pop up. I can answer them as they come in. So this is meant to be interactive. So honestly, if you have questions, now's the time to ask them. Another thing too is we will be sending out a feedback form and as well as an informational material for you. So the feedback form is great if you have any desire to set up an initial consultation with any of the attorneys in our office after this. That is where we don't reach out to you without you reaching out first. So if there's something you'd like us to do to set up a time to speak, that document gives you a place to mark that down and allows us to know that you're okay with us contacting you. Those initial consultations, by the way, are complimentary. We don't like to charge anyone to come in and talk to us initially because we just don't know what we need to do for someone right away without being able to speak with them, right? So that's really important. And there's no obligation after speaking with us that anybody has to do anything. It's a really good use of time, I think, for someone to come in and have their questions answered. And they're usually scheduled for around 2 hours or so. I mean, sometimes they take a little longer, sometimes they don't take that long. It really depends on how in depth the conversation needs to be on any given topic. I mean, for example, if we're talking about setting up powers of attorney for someone, their college age kid, it's probably not the 2 hours. It's maybe closer to a half hour to an hour, depending on the amount of conversation that needs to be had. When we're talking more about full estate planning, getting wills or trusts or, long-term care planning, anything like that in case, then it's, definitely closer to those 2 hour marks. But again, if you'd like us to reach out to you, that's a great place to do so. The other material you'll get from us is actually just sort of a summary of the documents I'm going to talk about today and why they're important and what they can do for you or your college age kid. Or I keep saying college age, but honestly, if this is even somebody in their mid-20s that doesn't have these, right? I mean, this is still applicable. But this sheet talks about these documents and what they do. And it's a good summary, a little cheat sheet of, okay, here's why I need this type of document for this purpose, or here's how I can have my parents or my loved ones have access to healthcare information. I mean, those are what are all sort of encapsulated in that document. What those 4 documents are really what we commonly refer to as documents that can plan for a disability or an incapacity, or really just help you step in for somebody, even if they have capacity, but they need that assistance with something. So those 4 documents are the power of attorney for finance. You'll see them often called like a general durable power of attorney, a healthcare power of attorney, a HIPAA authorization. So I'm sure many of you have signed HIPAA authorizations over the last 20 years or so, and a living will. So I'll go through each of those documents, give you a kind of a quick rundown on what each of them does and the different types of considerations that you'd want to have, or think about when you're having those drafted for yourself or for a loved one that you are, helping them put in place, right? So to really start with, the first of those documents, the general durable power of attorney, the financial power of attorney. What that document is where somebody can elect to have somebody step in for them as an agent if they are unable to do something themselves financially or legally. So what that means is, I'm not saying somebody can't legally do something, but if they need them to do legal work for them or have them hire an attorney on their behalf, that's what I mean by legal work. But this includes things as simple as like, hey, can somebody go to the bank for me? Can they pay my bills for me and write checks from my checking account? Can they move accounts around if I need them to for me and I'm unable to? Can they, participate and talk to advisors on my behalf if I'm unavailable? All of those sorts of things are included in a financial power of attorney. So it's a lot of the things you would think of like, hey, the paying the bills and making sure that, the accounts are being monitored and things like that. But it's more expansive too with things like, can somebody file your taxes for you? Or can they apply for certain government benefits for you if it's like somebody going into a long-term care facility and they need Medicaid potentially, right? So it's pretty broad. But the biggest concern I have with a lot of financial powers of attorney I see are that they don't explicitly state a lot of things. And the reason that's important is powers of attorney, especially powers of attorney for finance, are really only as helpful as the authorities they specifically grant. So the biggest issue I see is when someone comes in, they may have one, but it's the one they downloaded from the state statutory website, which is better than nothing. But the problem is when you look at the authorities on there, it's sort of a initial next to these authorities you would like to have your agent have for you, but it only names those authorities. It doesn't actually explain what any of them mean. And that can lead to a lot of problems, especially when you're looking at how does this bank interpret that authority versus my other bank, or how do I interpret this differently, potentially than somebody else might interpret this. And that's why the vagueness of those documents is very dangerous. And I mean, the state did the best they could with it. Obviously, they're not trying to be overly specific with it because it's meant to sort of be a broad tool for somebody to use. But that doesn't mean you want to use it if you have the option. So what you'd be looking for instead, as an example, is the state form might say, I grant banking powers to my agent. Well, what does that mean? Does that mean paying bills? Does that mean moving accounts around? Does that mean writing checks? Your guess is as good as mine because it really depends on how somebody else is going to be reading that. Whereas in a well-drafted power of attorney for finance, somebody would say, oh, it might say banking powers, but then underneath it, it will explain what is all included in there, for example. It'll elaborate so that it is not open to interpretation or as unopen to interpretation as possible, so that it is very, instructive of what somebody can do. You don't want to leave it up to someone's interpretation of whether banking powers means paying bills. You want it to include, the ability to write checks, right? You want that to be very clear. So that is why it's really important to look at getting this in place for yourself or for, a child that is becoming an adult, because without those authorities granted, as somebody becomes an adult, you as a parent no longer have that direct authority over them. It's the same thing with limiting access to information, right? I mean, the law does not assume that families get along. In fact, it assumes they probably don't, which, I mean, may be fair, may not be fair, depending on the family, right? But as a child becomes an adult, then that means you lose access to a lot of authorities for them. And it's not like the child is, wants to give away those authorities as they become an adult. A power of attorney is really sharing that power over that ability with someone else. It's sort of duplicating it. It's not giving anything away for that person. It's not saying I can't make this decision for myself. It's saying I also want so-and-so to make that decision for me if I can't. And I mean, powers of attorney for finance are incredibly helpful too, as somebody goes off to college or, is going to trade school and, trying to like figure out how adult life works. It takes a couple of years to get the full handle on that, I'm sure. So that is where, having the ability for a parent or a loved one or someone they trust to step in and, help guide them on it and have the ability to help them out when they need it is really, really helpful. I mean, for example, filing taxes is a big one that most 18-year-olds, if they haven't, had to do it as like a college or as a high school kid filing their income tax for that year, they might not have the experience of where do you even begin. And sometimes that's where that power of attorney can be really helpful too, is having the parent or a loved one help step in for that. Powers of attorney for finance are almost always what we call immediately effective. What that means is that the moment it's signed, the person who is the initial agent on there can step in and help out with those different things listed on that document. It does not require somebody to be declared incapacitated. The durable part of that just means that they will continue to be effective after someone's incapacity. So it's not just something that steps in or starts to play a role as someone loses capacity, but it is very important for when that happens too. When it comes to naming someone who you choose as that agent, people often talk about, well, I mean, I'm obviously now referring to people who are older who have adult age kids. They're usually looking at, well, my son or my daughter, they're a banker. So I know, they have the background for that decision, or they have the knowledge necessary to make the right decision. And that's helpful, certainly, having a doctor as a healthcare power of attorney, or the banker or financial advisor as a financial power of attorney. Those backgrounds certainly help them know what those decisions entail, but they don't necessarily, they're not necessary, I should say, to playing a good role there. What you really want to look for when you're naming an agent is you want them to be obviously trustworthy, because you're granting a lot of authority with these. So if you don't trust the person, that's the number one reason not to name them. But the other consideration is are they responsible in terms of paying bills on time? Are they, proactive about things, or do they procrastinate? And how busy are they, right? I mean, for example, a lot of times people talk about, oh, I'm going to name my son who's the doctor as my healthcare power of attorney. Well, again, the knowledge there is great, but how busy is that child? Are they able to play that role effectively, or are they going to need to delegate it to other people anyway? So it's not always about who's the smartest, right? Or who has the best background for something. It's, can that person do what you need them to effectively and on time? And do you trust them? And that goes to the financial and the healthcare power of attorney. But in particular with finance, I mean, you don't need that child or the person you're naming to have the knowledge themselves to make certain decisions. You just need them to be able to seek it out and have those authorities to make decisions then off of any advice they receive. So, looking at the financial power of attorney, that can obviously be very helpful, especially as someone is, going off into the adult world for the first time and having, the parents still be able to step in and maybe work with their accounts or help them file taxes is very helpful. The next document, the healthcare power of attorney, this is really important for probably the more important one in terms of when you are giving a child off to the adult world. And, you used to have the ability to make healthcare decisions and get healthcare information, but as they turn 18, you don't anymore. This is the one in particular a lot of parents are concerned about, because anybody, regardless of age, can have a health event or can get into an accident or, can have some sort of disability come up that they couldn't have foreseen. These things happen to healthy people who, again, there's no reason to believe it would happen, but it can. And if you don't have these powers through the healthcare power of attorney, you can't make decisions for that child anymore regarding care or anything else, that you don't have that right anymore as a parent once they turn 18. So it's really important so that your child has a healthcare power of attorney drafted where they're naming the people they want to be able to step in and make those decisions for them should they have an incapacity. And sometimes this is the hardest one to sell the child on, because it's, kids think young adults think they're kind of invincible, right? Oh, that'll never happen to me. I'll never have an incapacity, or at least not for a very long time. It's not going to happen. but it's important to still name the people you would want to step in for you. Even, I myself, for example, I don't anticipate having an incapacity, but I have a healthcare power of attorney that authorizes my family to step in if I need them to. I hopefully never need it, or at least not for a very long time, but you want it just in case. So this is, again, where that, like I said, that background, that medical background is helpful sometimes in terms of advice, but the biggest consideration when you have a healthcare power of attorney agent that you're naming is making sure that, again, do they get things done in a timely manner? Are they going to be available? And sometimes, actually, more so than the financial power of attorney, are they close by? Again, if the person that you need to name as a healthcare power of attorney agent, because that's your only option, it's the person you trust and it's the best fit, maybe they're across the country, it's still okay to name that person. But if you had two equally trustworthy people, maybe name the closer one first, because if you're in the hospital, you need someone close by potentially to make those decisions and to be there with you. So the healthcare power of attorney, then that's what's going to allow certain things like, hey, can I admit someone to a hospital? If they're incapacitated, can I make certain care decisions? And am I able to get access to information? And that also plays into the HIPAA authorization, but it is often included in a healthcare power of attorney. The big consideration with healthcare powers of attorney is that depending on how they're drafted, they might only be effective if somebody has a declaration of incapacity. So there's, in Wisconsin anyway, there's sort of, if two physicians declare you incapacitated, that means, it's activated under the terms of that document, but it can be drafted in a different way as well. And often what we do, for example, is we do not require that declaration of incapacity, so that if somebody just needs assistance in making a healthcare decision, maybe fully having capacity, that agent can still step in. So it's, there's not just one way to do it in Wisconsin. Now, state by state, that can vary, obviously, but in Wisconsin, you can do it, have it be immediately effective, just like the financial power of attorney. Or what you tend to see at a lot of healthcare, offices and administrations is of course, they do have the declaration of incapacity required in there. And it's just, again, they're trying to draft it for the broadest audience. So it's not like one is necessarily, malicious or anything like that. It's just that they're drafted differently. So you want to be very aware of what's required in your document that you have drafted for you. When does it become effective is very important. And, making sure that that person has the people they want on there named in the order they want them to act. So, these sorts of things are very important, especially for parents to have. The HIPAA authorization I sort of mentioned already. This one's kind of self-explanatory. If you've ever had any experience dealing with HIPAA, oftentimes people cite HIPAA when it doesn't actually apply. I've heard financial institutions cite HIPAA, and it's not. HIPAA is the law that basically says doctors are not allowed to, or healthcare providers in general are not allowed to release your health information, your private health information, without prior authorization. So that's where, they can't talk to somebody if they're not listed on a HIPAA authorization. Now, this often gets cited, like I said, where it doesn't apply, where it's, oh, well, I can't do this because of HIPAA. And you'll hear that from a financial institution. You say that, I get that you need authorization, but that's not the right law to cite. But in general, though, this is where a lot of people are unaware as their children become adults that they don't have access to this anymore. So a good example of this is somebody who worked with our office. They came into our office to talk about this kind of thing because of the fact that this had happened to, I believe, a family friend of theirs, but 19, 20-year-old son, I believe it was, a child, got into a car accident and was, they were fine, they were okay. I believe they were maybe in a medically induced coma for a couple days or something like that. So they couldn't release the information themselves at that point. But the child did not have a HIPAA authorization on file with the doctor, granting their family the access to that information. So for a couple of days until the child was able to grant that information or that release of information, the family couldn't figure out what was going on. They couldn't figure out if the child was even there or what had happened. So it's scary to think that, well, if something happens to a loved one, I might not be able to to know what's going on, just to even know that they're okay, right? Regardless of making decisions on it, are they even okay? And that's where having a HIPAA authorization, giving all of those people that you would ever want to have access to that information, so that you already have one in place, you already have one on file with your primary care physician that grants those individuals access to information. You have access to that up until age 18 as a parent, but once it's past that point, it's no longer just assumed that that's okay. You need that HIPAA authorization granting it. So this one is particularly important, just regardless of whether somebody has that parent named as the initial healthcare power of attorney agent. Is that child granting their parents even information access in terms of, setting up doctor's appointments or finding out if they're okay if there's an accident. And like, this is where I was talking about, it can happen to anybody, right? I mean, this is not just I'm likely to need care, but if I ever do, I sure want my family to know what's going on. And that's where that's really important. So, we've all signed HIPAA authorizations. I guarantee you, if you've had a doctor's appointment in the last 15 years, you've definitely signed a HIPAA authorization. But having a standalone one that you have for kind of widespread use is really helpful, because one, you don't tend to have an expiration date on it then, whereas depending on how it was drafted through a doctor's office, you might have to update it every so often. If you have one privately drafted, you can use it, as long as you are still okay with that list until you update it again. So there's no reason to not have a standalone one that you can have your family then hold on to. And if they need to present to hospital with it, if there's one not on file, they have one they can do that with. Oh, and I do see a question. Okay, sorry. Once you get the forms done, what should you do with them? So if you're going to college, and who should get the copy of the financial power of attorney, for example, and what? So kind of a really good question. With the financial power of attorney, I would say it's more important that the people you need to have access to those documents. So things like the people you've listed on it, in terms of if I named my mom or my dad, for example, as a power of attorney for finance, they should have a copy of it so that if they need to use it, they can have access to it. Sometimes banks will allow you to put them on file with the bank. Not always though. So that one, make sure your agent you've listed on there, whether it's a family member or a friend, they have a copy of it so they can use it when they need it. Or at the very least, they know where to find it. They don't do you any good if you just have one drafted and it's like thrown away into a safety deposit box, right? You need them to know where and how to get access to it. With the healthcare documents, this is one that it's really important to actually put on file with your primary care physician. You can't, it would be borderline impossible to put it on file with every possible hospital that you would ever need to have it. So this is another one to make sure that the agents listed on it have a copy, but definitely put it on file with a primary care physician. If you're going off to school in a different city, for example, if you have a primary care physician there, put one on file with them. And the reason that is the most important is usually if it's on file with the primary care physician, whatever hospital that you might need to go to in that area is usually part of some sort of health network there, or they have the same access to the same database. If it's, kind of one of those national companies that they use for healthcare documents. So giving them a copy is important, having it on file with the primary care physician. With the power of attorney for finance, just making sure that the agent that you've named down there has a copy of it is really important. And depending on how many backups you have, you don't need to give a copy to every single backup, because then you need to let every backup know if you ever change it that they are no longer able to act, right? So just the people who need to act are the most important, but definitely any institution you need as well. Same thing goes for HIPAA, by the way. Like I said, every doctor's office is probably going to have you sign a HIPAA, but having that on file with your primary care physician is also really important. A lot of times what I'll do nowadays too is, we have signed copies on file with our office, for example. So sometimes I'll send fully valid PDF copies to the people who need them if the client requests, so that they can make decisions of how they want to store it and have it on their phone wherever they go. I mean, I don't expect people to necessarily carry around like, hey, here's my paper power of attorney everywhere I go. I got to make sure I have it on the plane with me, right? So that having it on your phone is good too. If you're tech savvy, I suppose. Some of our older clients, they don't have smartphones, so that's not a doable option. But if you do, it's pretty easy. So hopefully that answers your question. I know that was a little long-winded, but really the takeaway from that is the people who need to make decisions for you that are listed on those documents are definitely should have a copy. The institutions you work with may want a copy as well, but definitely healthcare providers, if it's your primary care physician, put those on file. Primary care physician does not need your financial power of attorney, generally speaking. I mean, there could be reasons maybe, but most of the time, just the healthcare side of things. So that actually kind of leads me into another document as well that's really important to have, along with the HIPAA and the healthcare power of attorney, is a living will. So this is not like my last will and testament where I divide up my estate certain ways. That's important to have at some point. But that's not the most important thing for like an 18-year-old with really no property to have. It's the living will is where you mention whether or not your end of life wishes, whether you want to be on life support indefinitely, or you want to be removed from life support if you're not going to recover. What are your particular wishes with that? And this is really where you express those wishes so that, the healthcare power of attorney agent then knows what to follow. It really is what tells the person who needs to make that decision what those wishes are, so that they're not making a decision for you, they're just enacting it. So this is a lot of times you'll see one of these through a doctor's office. They generally don't present them to people under a certain age. I once had a client joke that I knew I was starting to get older when they started asking me if I had this document. For example, I've never been asked if I have one, although I think every healthcare provider should ask this question. But yeah, so if you see it through a doctor's office, it'll say kind of yes or no, check the box. I want this type of life support removed in this circumstance, or no, I always want that kept. But, when you have one drafted for you, it's a little more, gives more authority to the healthcare power of attorney to make the right decision for you based off of a more general guideline of what your end of life wishes are. For example, a living will drafted by our office would say, I don't wish to be kept on life support in the event that I am not going to recover, or it's just prolonging the process, or anything like that. And I do see another question here. So let's say parent one, mom listed as primary, parent two, dad is listed as first backup, and aunt is the third listed there, so the second backup. How does it practically work if the aunt shows up with the document, if they have to check? So basically how do backup agents work? So first and foremost, that if they have to show as a backup agent, somebody is truly unavailable. So these days it's a lot harder unless somebody really is incapacitated, or like they have a death certificate to show that that person can't act, because they'll always try to reach that agent first. And now the initial agent can delegate to that person. They have that authority. So if mom is the initial agent, dad's the backup, or mom and aunt, mom on the phone could say, absolutely listen to her in this circumstance. She's the one available, at least until I show up. For example, if someone's flying on a plane where their phone has to be off, or I suppose should be off, right? It isn't always. They might not be reachable in the event of an emergency. And at that point, the doctor should listen to the backup if they're present, because that's who's available. With finances, it's a little harder because almost nothing needs to be done, in an emergency, financially speaking. Usually they can wait. So as a backup financial agent, you would have to show that that person is incapacitated, most likely, or that they have passed away. The reason you have these backups listed in the first place is really so that there is somebody listed if that person is unavailable. You don't want to leave it up to chance that, hey, I'll just update it if something happens, because you might not have the opportunity to do so. So really, practically speaking, somebody does have to go through a bit more to show that that initial agent is not available, but it doesn't mean you don't list anybody, because there are plenty of times where maybe mom and daughter are traveling together, maybe there's a car accident, and then you need the backup, right? And you didn't have a chance to update it. So if you ever want someone, financially speaking, to make joint decisions or be able to make decisions with somebody, even if you intend for one person to kind of be primary. For financial powers of attorney, you can name co-agents. You can have them act together and have it be equal and independent so that they don't have to both be present, but either one can act. For healthcare, you can't do that. There does have to be an order. So that's where it can be. Healthcare, it's a little harder in terms of, a lot of people want people to act jointly. They're, if they're two kids, they want to act jointly, but you do have to pick one first. That's where the backup is going to be. If someone's unavailable, the doctor should listen to the backup on that. But like you're saying, practically speaking, it's not always, they're going to ask why the initial can't act. I mean, which they should, because you don't want a backup acting if the other person can. I mean, that's the reason they're a backup, not the primary. But with a living will, just to finish up with that, because I'm going a little short on time here. With a living will, the reason it's important, even for a younger person, right, is like I said, anybody can get into an accident. Anything can happen where somebody might be on life support now indefinitely. I mean, this happens to young people too. And the question isn't, do you think this is going to happen anytime soon? Because hopefully not, right? But if you were in that situation, do you want to be maintained on life support indefinitely? Or at a certain point, would you want that power of attorney for healthcare agent to say, along with the advice from the doctor, okay, it's time to remove that person from life support? And there's really no right or wrong answer here to that question. I mean, that's a very personal decision, but whatever your personal wish would be, it's important to have that listed so that somebody knows what to do. The other part of it too is it releases then that healthcare power of attorney agent making that decision. It releases them from personal liability for making that decision based off of it. They're just following your wish then. They're not making a healthcare decision for you that you wouldn't have ever wanted. So it's really important for just liability's sake for that person then have that codified. And it's like I said, it's a very personal decision on which way somebody goes with that. There's no right or wrong way. But whatever option you choose, whether it's to be maintained indefinitely on life support or to be removed, make sure you know what, make an informed decision on that, right? Get the kind of all the repercussions of that. So that the 3 documents though that you absolutely want on file with your primary care physician are definitely the healthcare power of attorney, the HIPAA authorization, and then the living will. Those 3 are very important. And just be very aware with healthcare powers of attorney and living wills in particular, you can accidentally revoke your ones that you had drafted for you anytime you sign a new one. So if a doctor's office gives you advanced care directives after you've signed your own healthcare power of attorney, you don't want to sign that new one unless you are intending to revoke it for some reason, but it happens all the time, which is why I bring it up. So it's just something to know. Okay. So I can answer one last question here, it looks like, and then I'll have to, if anybody has any additional questions, you can always email learn more at hooperlawoffice.com or set up a time to talk with one of us. But the last question is, how does the organ sticker, your organ donor sticker on a driver's license play into this versus a living will? Do you suggest that the organ sticker be used or identify organ donation on legal documents instead? We do, in healthcare powers of attorney, we do have certain authorities granted in there about making organ donation decisions. So, I mean, the organ donor sticker on a license plate on a driver's license is sort of separate from the power of attorney. It's sort of indicative of what you would want, but it's also good to have those wishes listed. Or if you never want that listed on there, right? I never want organ donation. That's also important to know so that it can be customized to that. I mean, some people really, maybe for religious reasons or just personal reasons, don't ever want organ donation, or like don't want scientific research allowed, or whatever it might be. Those are important to put in both the healthcare power of attorney and the living will as well, just to make sure that that's very clear what your wish is. They're not they don't conflict with one another. Although if one has the organ donation sticker on the license plate and then you don't have it on your healthcare power of attorney, that would maybe be confusing. But really, the healthcare power of attorney and the living will would probably override in terms of any sort of debate over whatever the driver's license sticker is, right? Because somebody might have changed their mind after they got that driver's license. Really, the power of attorney is going to be the most likely most up to date. So definitely put those wishes in a power of attorney for healthcare, or at least in a living will, so that the person making that decision knows what to do. There's also a document called an authorization for disposition of final remains too. That is another sort of like, think of it as a power of attorney for your remains after you're gone. What type of burial you want, what if you want organ donation, do you want to allow like cadaver scientific research? I mean, there can be a lot of things listed on there too. So with that, I'm a little over time, but please, if anybody has any questions that we didn't get to today, there's a lot of very specifics with this, so I understand if there are. Please feel free to email learnmore@hooperlawoffice.com, and we'll see those questions come through. So our topic next week actually is we're talking about what's called the Secure Act. So this is going to be a little different than if you're, a new adult, because most new adults don't have retirement accounts yet, like 401ks or IRAs. But our topic next week is about the Secure Act, which changed how those accounts work in a lot of ways. They changed some things during the lifetime of the account holder in terms of certain ages that you have to start taking things out. But it's also changed how they work in terms of someone inheriting those accounts. That doesn't meet a very kind of minor exception, a few minor exceptions to the rule. So if you have a retirement account and you want to know how that has been changed in recent memory, that's good to tune in for that, because it's actually impacts a lot of people's estate plans if they haven't been updated in the last year or so. So it's good one to tune in, and that's same time as this, one was today. So noon every Wednesday is when we do these, but please feel free to sign up for that, and I will see you guys next week.